What happens when someone copies your work without your permission? Who actually owns a song, a photograph, or a film? And how does Indian law decide what deserves protection? Today, we are breaking down the Copyright Act of 1957, the law that protects creativity in India, from its foundation to key legal definition. This video will give you a clear structured understanding of how copyright works. So let's begin. The Copyright Act 1957 is the primary legislation governing copyright law in India. It was enacted in the 8th year of the Republic, and the objective of the Act was to amend and consolidate existing copyright laws in India. So in simple terms, it brought clarity and uniformity to how creative works are protected. This Act is officially known as Act number 14 of 1957. It was passed on 4 June 1957 and it came into force on 21st January 1958. Its jurisdiction extends to the whole of India, which means any original work protected under Indian law falls within its scope. So whether you are writing a novel, composing music, shooting a film, designing a logo, or creating digital content, this act safeguards your rights. In common language, we assume the author is simply the creator. But in copyright law, the word author has a technical meaning. Under Section 2D, authorship depends on the type of work. So let's look at this carefully. For literary or dramatic works, the author is the writer. This includes books, scripts, articles, blogs, and even speeches. For example, if you write a screenplay, you are the author of that script, even if someone else directs the film. For a musical work, the author is the composer. This is often misunderstood. The singer is not the author. The lyricist is not the author of the musical work. For example, if a composer creates a melody and a lyricist writes words for it, both have separate copyrights. Then for artistic works, the author is the artist. In case of the photographs, the author is the photographer. For example, if you click a photograph, you own its copyright, even if it is taken on your phone. For cinematograph films and sound recordings, the author is the producer. And this explains why producers usually own film rights. For computer-generated works, the author is the person who causes the work to be created. For example, if you use software or AI tools based on your instructions, you may be considered the author. Not everything created automatically gets copyright protection. The Act recognizes specific categories of works. The first is artistic works, which includes paintings, sculptures, drawings, maps, charts, diagrams, engravings, photographs, and architectural designs. For example, a building plan drawn by an architect is protected as an artistic work. Even a logo or illustration can be protected. Moving on to second one, musical works. A musical work consists of the music itself and its graphical notation. So here is a crucial legal distinction. Lyrics are not part of the musical work. They are protected separately as literary works. For example, copying a tune without copying the lyrics can still be infringement. Next is cinematograph films. This means any work of visual recordings and also includes the accompanying sound recordings. For example, movies, web series, short films, and reels are all protected under this category. Now let us understand how a work reaches the public. Communication to the public means a work available to be seen, heard, or otherwise enjoyed. This includes transmission through satellite, cable, wire, or digital platforms. The most important part is that actual access is not required. Availability alone constitutes communication. For example, uploading content online counts as communication, even if no one is watching. Now, publication. A work is said to be published when it is made available by issuing physical copies or by communication to the public. For example, printing books is publication. Uploading ebooks or music online is also coming under publication. Copyright law exists to prevent misuse of creative works. Now let us look at the two critical definitions. Infringing copy given under section 2 clause M. An infringing copy is any reproduction made in violation of the act. For films, any unauthorized copy on any medium is an infringing copy. For example, pirated downloads, illegal CDs or unauthorized sharing are all infringements. Next is right management information. Section 2 clause XA. This is the digital identity of a work, which includes the title of the work, the author or performer's name, the rights owner's detail, and the terms of use. For example, metadata on streaming platforms or digital credits are forms of right management information. Removing this information can itself be illegal. Understanding these definitions is the foundation of copyright law in India. They determine who owns a work, how it can be used, and when infringement occurs. In the next video, we will move into chapter 2 and discuss how copyrights comes into existence and how ownership is determined. If you found this video helpful, like, share and subscribe for more structured legal content. Thank you for watching.